Hi, in this video, you will learn what is an acceptance in contract law and key cases about it to help you get high grades in your upcoming contract law exam or coursework. I'm Nini, founder of Simple Studying. I have LLB and LLM degrees from City University of London. I have got very high grades in my law exams when I was at law school. Then I founded Simple Studying to help law students get high grades. At Simple Studying, we are building an AI-powered higher education and career-building tool to help UK and US university students get high grades and build successful high-income careers. Why you should trust us? First of all, we have 25,000 registered customers already on our platform in the UK, and that's like 25% of total law students in the country. 90% of our regular customers who have got premium services have reported to have got a first class. That's premium membership plus at least 6 hours of tutoring per exam. After working with thousands of law students in the UK, we know exactly how to get a first class. What is a contract? Contract is a legally binding agreement with offer, acceptance, consideration, and intention to create legal relations. What is an acceptance? Acceptance is unqualified expression of assent to the terms proposed by the offeror. Accordingly, there is first an offer, and then all the terms of the offer must be accepted, must be consented to. Acceptance of an offer must be communicated for a contract to be created. An offer on its own terms does not lead to contractual liability. It requires acceptance, consideration, and intention to create legal relations. Just an offer is not enough. Acceptance must be communicated. See the case of Entos versus Miles Far East Court. Acceptance must be communicated. That's the principle that came out of this case. Acceptance is only validly communicated when it is brought to the attention of the offeror. Offeror does not need to confirm that she had the acceptance, but it should be brought to her attention. See the case of Hyde versus Ranch, for example. Defendant offered to sell some land to the claimant for £1,000. Claimant replied by offering to purchase the land for £950. Defendant refused to sell for this price. Then the claimant accepted £1,000 price, but defendant did not want to sell. It was held that there was no contract because claimant's offer of £950 was a counter offer. So counter offer actually cancels the original offer, and since the original offer was cancelled, it could not have been accepted. Ignorance of the offer. See the case of R.V. Clark. This is one more situation that may happen. It can come up in a problem question on your upcoming exam or coursework. In R.V. Clark, the government advertised an offer of a reward. £1,000 for information leading to the arrest of murders of 2 police officers. Clark saw the offer but forgot about the word. The issue in this case was, can there be an acceptance without knowingly accepting the offer? So in other words, can the claimant ignore the offer and still create a valid contract? It was held that the answer is no. Acceptance cannot happen without knowledge of the offer. Ignorance of the offer is the same thing as never hearing of it or forgetting after the hearing. So, claimant must be aware of the offer. Cross offers. That was a case in Teen versus Hoffman. Mr. Hoffman, in this case, wrote to the claimant, Mr. T, with an offer to sell him 800 tons of iron. He requested a reply to this offer by post. Tin replied and offered to buy the iron on similar terms, but not exactly the same terms, just similar terms. The issue was whether or not there was a valid contract. It was held that the contract has not been created because the cross offers were made simultaneously without the knowledge of one another. To form a valid contract, there must be a valid offer and acceptance. Prescribed method of acceptance. What does it mean? The general rule is that the offeror is not bound unless the terms of the offer are complied with. See the case of Manchester Diocesan Council for Education. In this case, claimant decided to sell property by tender and inserted a clause stating that the person whose bid was accepted would be informed by letter. The defendant completed the form of tender and sent it to the claimant. However, the problem was that the address was wrong. It was sent to another address than it should have been. It was held that there was a valid contract. Communication to the address in the tender was not the sole permitted means of communication of acceptance. So this means that even if it was not accepted in the way that it should have been, the contract still stands. Acceptance by silence. Generally, silence will not amount to an acceptance of the offer. This was held in the case of Falcoes versus Bindley. Reselect move is also an important case here. Silence can amount to acceptance if the offeree has specifically indicated that the offer can take the acceptance as read unless the offeree says otherwise. So in some cases, as we saw in reselect move, silence can be a valid acceptance, but in only specific scenario if the offeror has specifically said that this could be the case. Acceptance by post. You should remember these cases because most likely this will come up on your exam. It often does. Postal rule. Acceptance takes place when the letter of acceptance is posted by the offeree. That's the case of Adams versus Liesel. So the letter of acceptance does not need to be received or read by the offeree. It just needs to be posted. It just needs to be sent by post, and that's enough. Even if the letter of acceptance was lost in the post office, it's still effective as long as it was posted to the right address. However, acceptance will not be effective if the letter was sent to a wrong address. It has to be sent to the right address. Only in that case, acceptance by post will be valid. Have a look at our contract law study materials on simple studying to learn more. We have all the simplified and condensed study materials in contract law you need to get a first class.